All right, welcome back again to Civics. It's February 2021. As part of our recognition of Black History Month, what we're going to do here today and discuss is three important U.S. Supreme Court cases that kind of trace civil rights issues in the United States. So, this is a civics class, not a history class. In civics class, one of the NGSSSs, one of the things you have to know and common questions on the EOC are connected to important decisions our United States Supreme Court has made. So what I've done is taken three of the ones that are testable and things you need to know on the EOC and show how the Supreme Court has made decisions that change how the United States looks at civil rights issues in our country. We got to start with a very short history of slavery. Very short history. It's not a history class. I cannot do history in the United States, slavery in the United States justice. But let's just review a couple things as a start point for these important Supreme Court cases. Almost as soon as the colonies start, slavery is imported here. Slavery is traced back to 1619. So almost to the very first years of colonists being settled and operating in the new colonies here in North America, they began the importation of slaves from Africa to basically be property, to basically do work for the colonists. You will see in the history of North American slavery, something mentioned the triangular trade route. Just bring this up really quickly so you understand the bigger picture, how slavery works. So, slavery is a human problem. It's not just something that's restricted to this time period. So the slavery of this time period, the system worked like this. Europeans would buy slaves in Africa using manufactured goods that weren't produced in Africa. So everything from cloth to mirrors to guns to machinery, farm equipment, etc. that would be imported to Africa and sold to people. Slaves would be bought. What's a slave? Human being like you and me. Typically kidnapped, captured, prisoners of war, captured by these slaver groups, brought to the coasts, held basically in concentration camps, sold, put on ships, and the ships would be brought to South Central or North America to be sold as property. When they got to South Central, the Caribbean or North America, they were used typically as what? Workforce in typically where? Agricultural plantation settings. Did these people have any rights? Typically not. They were treated as property, brought to the colonies to be used as agricultural or domestic workers. Fast forward. Slavery really becomes extremely important in the economy of the southern colonies and the southern states. The southern states had these huge farms called plantations, where they would be growing tobacco, rice, cotton. Instead of using paid labor or machinery, they would use slaves. So these slaves were used in the place of paid labor or machinery, to the point where the southern economy relies upon slave labor. The southern economy, southern business, is held up, propped up by this foundation of chattel slavery. Human beings that are not treated as humans with any kind of civil rights that are doing their labor. Questions? Fast forward to 1858. We're getting to where this first Supreme Court case is going to be a matter. Okay, so by 1858, the United States is basically split into free states and territories where slavery is not practiced, and slave states and territories where slavery is happening. During this time frame, one of the biggest political issues in the country is slavery. And the question is, what happens in all these territories? Are they going to be free states or slave states? The southern states are very concerned that if free states outnumber the slave states, that the free states, their representatives and senators, will outnumber the political power of the slave states, their representatives and senators. And then, if they're outnumbered, if the slave states have less political power, eventually slavery will be found illegal, unconstitutional, and slavery would be stripped away from these southern states. These southern states, their economy depends on slavery, and not just their economy, their social structure. Their jobs, their money, their businesses are held up by this concept of slavery and this practice of slavery, and their social systems are all based on this idea that you have white people that are citizens and black people who are not. So it all comes to a head with this man named Dred Scott. He is going to bring a case about slavery to the Supreme Court. Let's do a quick review about the Supreme Court. The United States Supreme Court is the highest court in the land. What does that mean? It says what the Constitution says. It interprets the law. So these 9 justices on the United States Supreme Court look at the law and decide what it means. It says what the Constitution says. So when it makes a decision in that case, all the other courts in the United States follow that decision. That is called a precedent. The Supreme Court decides, says this is what the law means, then all these courts all throughout the United States follow that Supreme Court precedent. When you see these things spoken about or annotated, you will see something versus something else. Marbury versus Madison. Dred Scott versus. Versus is just Latin for against, and the names in there are the parties to the Supreme Court case. Does that make sense, Abby? Mm-hmm. All right. The first case we're going to look at is the case of Dred Scott versus Sandford. It happens in 1857, and the real question that the Supreme Court has to decide is, who is a citizen? So, it all revolves around this man named Dred Scott. Dred Scott was a slave, and he was owned by a military officer who was a doctor. Just like the military today, military back then, you didn't stay in one place, you traveled around the country. So, this doctor traveled from slave states to free states and territories in the north. Once this happens, Dred Scott says, hey, I've lived in free states and territories. That should mean I'm free. And he sues to that effect. He basically sets a lawsuit saying, hey, look, I should be freed because I have lived in these free states and territories. Of course, the family that own him aren't going to free him. They fight this suit. The lawsuit goes through 2 levels of lawsuits until it goes to the United States Supreme Court. The United States Supreme Court gets the case, and unfortunately for Dred Scott, the United States Supreme Court says, sorry, Mr. Dred Scott, slaves are not citizens. Since you're not a citizen, you can't sue for your freedom, so you are not freed. There's a second half of this too. The Supreme Court questions the constitutionality of this whole idea of free states and slave states, saying that, hey, look, it's an unconstitutional violation of the rights of Southern citizens. They should be able to move their slaves around as they see fit. This is the Supreme Court Chief Justice, man named Taney. Where do you think he came from?
The South.
He was a Southerner who owned slaves. So were some of the other Supreme Court justices at the time who ruled against Dred Scott. So, in 1857, the United States Supreme Court, the supreme law of the land, says African Americans, slaves, you are not full citizens. Don't expect your full rights under the Constitution. Historians today look at this Supreme Court decision and say, this is a terrible decision. The Supreme Court messed this up. They got it wrong. Longer story of Dred Scott. He does finally wind up gaining his freedom. And unfortunately for him, he only lives a few years as a free man. But he fought for his rights. And he did enjoy some level of freedom at the end of his life. 1857, Abby. Do you know when the Civil War is going to be?
No.
1860-61. This Supreme Court case is also considered one of the final steps to the United States Civil War. When this decision's made saying slaves are not citizens, what section of the country says, Supreme Court, you did an awesome job?
South.
The South. What section of the country says, Supreme Court, you did a terrible job and you messed this up?
The North.
To include this new political party. What is the new political party that's going to start about this period of time? And it starts off as the anti-slavery political party. Republican Party. So we're going to see at the same time frame, this new political party starts. The Republican Party, with the part of its platform being an anti-slavery platform, and they're eventually going to nominate this guy who becomes president, whose name is?
Thomas Jefferson.
Different name. Abraham Lincoln,
Oh,
who's going to be elected president in 1860. And that's going to be the final straw that breaks the camel's back. The Civil War starts basically right after Lincoln becomes president, with the South saying that slavery is imperiled with the election of Abraham Lincoln, and we fight the United States Civil War. So now we are after the Civil War. We have seen the 13th, 14th, and 15th Amendments. We're now at 1896. We're going to look at the case of Plessy versus Ferguson. And we're going to see whether separate but equal is constitutional. So, we may remember a while back, the United States Civil War ends in 1865. The 13th Amendment, which is ratified in 1865, ends slavery. 14th Amendment gives African Americans full equal protection under the law. And the 15th Amendment is even going to give African American men only, because women's going to have to wait till the 19th Amendment. But the 15th Amendment gives African American men the right to vote. Great. But after these things happen, the 13th, 14th, and 15th Amendment, is it all happy days and African Americans are given their full civil rights?
No.
Absolutely not. So what we have here is Plessy versus Ferguson. So this man, Homer Plessy, he's 7/8 white and 1/8 black. He knows in his state, Louisiana, railroad cars are reserved for either white citizens or what they'd call back then colored citizens. He is going to do this on purpose to challenge the law. He sits in a whites-only railroad car, absolutely deliberately, so he is challenged and arrested, and that's exactly what happens.
How can I even tell? Did he look 1/8 black? He looks white to me.
Excellent question. I don't know. But this is another interesting...
They have like a card with all their DNA history.
This is another interesting thing at the time. In a lot of these southern states, this is all that it took for you to be considered a colored person, and then you'd be subject to these segregation laws. All you had to have is that one black ancestor, and you're considered black. Now, I don't know how the train ticket taker guy, the conductor, could tell whether he was colored or white. But he could, and he admitted it because he wanted to force this case. So the conductor gets the police. He gets moved. So now he has a reason to sue, which is what he wanted to do in the first place. When his case gets to the Supreme Court, in another terrible ruling, the Supreme Court says segregation is fine as long as the facilities are separate but equal. So these laws that have a black railroad car and a white railroad car, the Supreme Court at the time says yes, separate but equal is constitutional, it's legal. So, is this just with railroad cars? Of course, absolutely not. Particularly in the South, literally everything would be segregated. Hospitals, schools, restaurants, etc. So now, the highest court in the land is saying segregation is fine. Separate but equal is legal and constitutional. Is this too, like Dred Scott versus Sanford, considered one of the hugest errors in the Supreme Court's history? Yes.
Did they segregate, like, courthouses?
I think a courthouse would be tough to segregate.
I think they definitely, like, I think it was kind of like the bus or, like, transportation thing. Like, I'm pretty sure black people had to sit, like, at the top.
Yep, famously in buses, because we'll see with Rosa Parks later on, that's one of the places. Again, in the South, probably effectively, most of the things you did, there was some level of segregation involved. Can it be in everything? Of course not. But in a wide range of things, if you were a Southern citizen at that time, whether you were white or colored, would you know that there's some things that's whites only and colored only? Absolutely.
Did they segregate, like, beaches?
They did segregate beaches. Yes.
How? Like a
Like a line
They'd have
drawn in the sand?
They'd have signs posted, and then they'd have people who were there to enforce the law. So we'll see. That's why I made this slide. Some of the examples right there. Okay? Oh, and I added this one. Make sure you understand, it wasn't just African Americans that faced some of these segregation rules. Asians and Hispanics faced similar ones in different parts of the country. So to review again, Plessy versus Ferguson, 1896. We're now well after the Civil War. 13th, 14th, and 15th Amendments. The United States Supreme Court basically says, even though we have the 13th, 14th, and 15th Amendments, we can have laws that provide separate but equal facilities. You can't ride in the white rail car. Why? Because there's a separate but equal facility for you, a colored rail car. The big place where this is going to come to a head in school. First, do you think these things were really separate but equal?
Definitely not.
Yeah, and we'll see that but equal part was a big flaw in the whole system. They were definitely separate. Were they equal? Absolutely not. So, segregation was something you saw in potentially any part of the country, but it was huge in the South. They had these black codes or Jim Crow laws that set this up by force of law. Again, order the police department who would enforce these laws. So we're going to talk about next and where this desegregation fight is going to really come to the head is in schools. So schools were segregated, again, particularly in the southern U.S. You had an African American school, a colored school, they'd call it at the time, and a white school. We go all the way to 1954. So we're talking almost 100 years after the 13th, 14th, and 15th Amendments, and a good almost 60 years after Plessy versus Ferguson, to the next Supreme Court case, which is Brown versus Board of Education. This will be a challenge against the separate but equal policy being constitutional, and specifically in the area of schools. So, Linda Brown, all she wants to do is go to school. She could have gone to the school that was close and convenient to her house, which was only 7 blocks away, but that was a segregated school system. It was for white students. The colored school was further away, and to get there, she basically had to walk through this dangerous railroad yard. So her parents say, of course, this is ridiculous. Her parents get backed up by this interest group called the NAACP. So the NAACP, which was an interest group that was working for the rights of African American citizens, and a bunch of these families say, okay, we're going to challenge segregation. The first part you have to do is you have to go to that school board and say, I'm 7 blocks away from this school. My daughter should go there, which is exactly what the Brown family did. Board of Education in Topeka, Kansas said, no, you got to go to the black school or the colored school. Lawsuit. These lawsuits work their way through the court system and finally get to the United States Supreme Court, the highest court in the land. And the United States Supreme Court finally gets it right. In 1954, they issued the decision, Brown versus Board of Education, and they now cancel Plessy versus Ferguson. They now say, we got it wrong in 1896. They now say, separate but equal, which was constitutional in 1896. We're saying it is unconstitutional now. You cannot say we have separate but equal facilities and say that's consistent with the 14th Amendment, which say we all get equal protection under the law. Supreme Court's going to say, clearly, separate but equal is problematic because, one, they're going to argue it is not equal, that they are unequal, and two, the 14th Amendment would say we all deserve equal protection under the law. So the great victory in the courthouse happens in 1954 with Brown versus Board of Education. There's some of the lawyers celebrating. Thurgood Marshall, who's going to be the lead lawyer in this case, is going to be our first African American Supreme Court justice. So as soon as the Supreme Court issues this ruling in 1954, do all states quickly, easily, and happily integrate their schools?
100%.
Of course not. So almost immediately, the southern states in particular, which would be most affected by integrating, bringing the races together into the schools, start protesting. Do you think this kid has any idea what she's protesting about, really?
No.
Probably not. These kids look like more middle schoolers or high schoolers. Do these kids probably know what they're doing?
Yes, for sure.
I think at some point, this kid and these kids are different. So, again, particularly in the southern states, the southern governments and their citizens start immediately protesting against and fighting against school integration, to the point where southern governors would refuse to let these African American kids into their schools. Again, just because the Supreme Court makes a ruling, does that mean everybody's going to follow the rules? No. The southern states in particular say, hey, by the 10th Amendment, we have states' rights. And one of these rights are, we don't think you can integrate our schools. Do these people know exactly what they're arguing about and protesting? I think this is interesting too. Can Can you read this sign?
No.
Don't push our children out
Oh.
the back door and let the communists through the front door. So somehow,
Black people are communists.
well, the idea of integration was considered a communist idea.
How?
We're talking the 1950s here. Communism was a huge threat, and basically,
Well, yeah, but like how does integration have anything to do with the definition of communism?
probably nothing.
Oh, all right.
But what you heard then, and you even hear today,
basically anything they didn't like. was
anything they didn't
communist.
like was communism, just like
Yeah.
today. Anything you don't like is socialism.
Right.
So integration, by no stretch that I can think of, is linked to communism. I guess you could argue, well, it's because the federal government is forcing them to do that, and that's somehow communistic. I don't get it, but it was a common argument at the time, and I was interested but not surprised to see that, because integration was one of the arguments the southern states made against it. It was an overreach of the federal government's power, and it was somehow communism to have black kids and white kids in the same school. Whatever. And this says segregation was planned long before the Supreme Court.
What?
I don't know. Do their arguments have to make sense?
Nope.
But do they seem very convinced that they're arguing for the right thing?
Yeah.
So this is what it took in many of these states. It took, no kidding, United States Army troops to get these kids in the school. Because they not only had to deal with civilian protesters, but they also had to deal with the state government. Some state governments actually put state police to prevent the kids from going into school. So you would have scenes where the United States Army would have to get these kids in past the state police so these kids could go to school. So the president at the time for a lot of this was President Dwight D. Eisenhower. He was an ex-general. He wasn't a big fan of integration either, but he was the president, and he said, the Supreme Court made a decision. Guess what? You are going to follow the law. So he used the United States military. Can you imagine?
Seems like a fun way to go into school. Definitely not scary at all.
Horrible. I can imagine how brave these kids are. All they want to do is go to school, and they got to march in between, armed soldiers to get to school. Famous picture. This is in Little Rock, Arkansas, integrating Little Rock's high schools. So, what do we learn? I hope you learned the three key Supreme Court cases. Dred Scott versus Sanford. The United States Supreme Court in 1857 says, slaves aren't citizens. Generally regarded as a terrible decision by the United States Supreme Court. That's followed up not too far from that. Plessy versus Ferguson, which says separate but equal is constitutional. Hopefully we realize that is another terrible Supreme Court decision. And finally, 1954, Brown versus Board of Education, which says separate but equal is unconstitutional, and we have to end, even if it takes United States military troops to end it, we have to end this system of segregated schools, which is going to lead to the end of segregation and everything else too. Questions?
Mm-mm.
Happy February.